in MPT cases, they just do the MPTC and then leave the victim. So this is an offense, and then all the person who got the knowledge will be punished. Then police to follow in the juvenile POCSO Act. Statement recorded to be child sensitive, as I told you, and in the language spoken by the child. Consent and reporting is mandatory. Reporting is there under POCSO, and protective custody and observations. In all juvenile justice cases, the observation homes, place of safety for juveniles to be provided, and special homes. These homes are run by the government, and in some cases it is by the NGOs. So victim has to be, even the juvenile person in child in conflict with is also to be treated as a most important person. Victims kept safety during trial if needed. During the trial, if the victim of POCSO faces any fear of this thing, then she can be conducted in the kept in the shelter homes. Then victim compensations has been provided. Justice Madam has been emphasized on this as per our 357 ACRPC with the provisions, and the NALSA fund is there, special, then also SALSA. Then DLSA is responsible for the disbursement of the fund. Compensation fund is available, state victim compensation fund is available, and then BNSS mandates victim-centric files allow compensation claims. Compensation in one of the judgment, Bijoy versus West Bengal court, the court has also emphasized to give more compensation other than the regular required compensation, since the state has the responsibility to protect the children and failed in its activity. So in-camera trials, most specified, mandatory in-camera trials are there. Mandatory in-camera trials to be conducted, which is already in place. So especially establishment of our court in Hyderabad city is one of the greatest court for the child specific this thing. Then speedy trials, Juvenile Justice Board to conduct a trial in 4 months, but child friendly and fast track courts as per the POCSO Act, the judgment shall be completed after taking the cognizance in 1 year. So time bound investigation for the police officer in 60 days, and this is also being seriously monitored by all the child sexual abuse cases and also rape cases by the Government of India Ministry of Home Affairs. So non-disclosure is one of the important provisions available under the Juvenile Justice Act for 74 and also section 23 of the POCSO Act. Then disclosure also is an offence under BNS 72. Presumption clause is there. This section presumption clause, that is age, has been much talked on this by Sir Bhupati sir. There is abatement clause under POCSO. Whoever abates, then the punishment is there under 17. The presumption is very, very important clause. This the accused has to prove his guilt. Then public awareness is one of the important arena in which all stakeholders have the responsibility to conduct public awareness about the POCSO Act and JJ Act and the offences committed. In this aspect, the Bharosa centers are doing a lot of work by analyzing the hotspot analysis and then conducting awareness campaigns. This is some just words that we have to conduct copies to the victims. No face-to-face meeting of the child accused, and no to keep the children in the police station beyond sunrise and sunset. No publishing of material. Safe corners. In recent times, we have opened many safe corners in the police stations for dealing with the POCSO as well as the juvenile cases. There is beautiful institutional mechanism as established to provisions have been provided in Telangana. One is that Bharosa, you all know that Bharosa officers are also is there. A single window system, support primarily towards quest for justice delivery and rehabilitation. It's a 24 hours running organization, and video conferencing facility is also there. In some of the cases, honorable magistrates have conducted video conferences. Recording 161 statements by the police officer. In all Bharosa Center, one sub-inspector of police has been provided. One of its kind child-friendly court was established in Hyderabad city. It's a paperless center administered by the Bharosa Society, headed by the Women Safety Wing Additional DGP Madam. and child rape and child sexual abuse cases have been taken. Initially it was opened in 2006 with one center, but in 2021 it was started in a massive way. By now we have created about 29 centers across the Telangana state, each district having one Bharosa center, and in tri-commissioners we are going to have 2-3 centers in each district. Thereby we are going up to 35 centers. Immediately, as soon as the victim comes to the police station, she will be immediately sent with a requisition to the Bharosa society, where the Bharosa people will go, and then victim will be examined by the psychological person, who is psychologist is already recruited there, and she will examine the victim, and thereafter, after talking to her, after conducting an interview, then she will put to before the police officer for recording the statement under 24 of the POCSO Act, and then medical examination also conducted in Hyderabad city. We have the facility, in some other district center we do not have, and that if that facility has been provided, the long waiting of the victim at the hospital will be avoided. Then we have the legal facilities. The legal support person is provided for handling the victim and their legal rights, and also accompanying the victim for recording 164 statement at the court, magistrate court. Rehabilitation rehabilitation has been provided. Shelter is being provided by producing before the CWC. We will outreach to generate awareness. And the beauty of the Bharosa Society and Bharosa Center is, we have provided the victim compensation fund about ₹1 lakh in the each Bharosa Center to meet the immediate medical expenses of the victims of the sexual abuse. And this is a feather in our cap that the Honorable Supreme Court in Nipul Saxena versus Union of India has categorically stated to provide one-stop centers, and one such center which is already been set up is Hyderabad Bharosa. This can be used as a model for another one-stop centers in the country. So we have also provided the institutional mechanism provisions. Is child-friendly corners have been created. 10 centers have been created in Sangareddy, and already in operational. With the help of UNICEF, we have taken the assistance from the UNICEF also in providing these centers, where the victims of juvenile children or child in conflict with will be provided, and also we are using these centers for the victims of sexual abuse. Infrastructure in place. These are the places we have already created. This is a reserve opened. This is the creation of our juvenile justice, special juvenile police units. Pre-protection rules also we are following for the children under Rule 16 of the JJ Act. No FIR shall be registered like that. And forwarded the nature, the probation officer facilities are being used in the cases. And these are all the prohibited. Production of the child is to be in conflict with the law before the board. No handcuff for the children, and not used or coercive forces. Inform the charge made against the children through the parents and guardians. Not to compel the child to confess his guilt, like parents, guardian may be present during the interview of the children. No feeling of custodial interrogation. Not to ask the child to sign. CWP shall be in plain clothes, which we are ensuring. And general principles is one of the important area we are focusing. The diversional alternative principle we are implementing in Hyderabad through she teams, where the victims of children in conflict with law who are caught by the she teams are being diverted at the police station itself by taking an undertaking from them and conducting counseling. Then principal assessment is one of the important area where principal magistrate will conduct the juvenile justice board for the conducting trial of the accused of 16 and 18 years age. This is wage verification, sir, as Ali categorically treated. Sir, here we are facing and we need your intervention here. The most of the police cases, when we see the FIRs, only the bona fide certificate are being submitted with the charge sheet. Bona fide certificate is not a valid certificate. So I think we need some good insight on this, because many of the problem we are being facing on ground is that many of the victims are illiterate. They do not have the birth certificate.
For that also there is an answer by the Supreme Court.
Yes, yes.
TC is also not accepted.
That TC is also not accepted. Study certificate is also not accepted. Only the matriculation certificate accepted. Board certificate.
Those mentioned.
Matriculation and board certificates, sir, and also municipality and corporation and panchayats. The problem we are being facing is that the children are illiterate. they do not have the date of birth. Only we have the evidence is that Aadhaar card, which is not admissible. And the last availability is that bone ossification test. In many of the cases, it is going in favor of the accused because the doctor is giving the his opinion between 17 to 18 years, and sometimes are 16 to 18 years, and in sometimes it is 16 to like that. So that is also the problem. And also here in bone ossification test, since we have to expose the children for the radiation, this thing, that is also posing danger to their health sir.
So also driving license,
yes,
and Aadhaar card also not accepted.
Not accepted, yes, sir, that's what, sir. So this is actually for the consumption of our police officer. I have specifically made this slide. Then in this recent Honorable Supreme Court judgment again reiterated that in the form of school register was not sufficient to arrive at the conclusion that the POCSO cases were less than 16 years. So invariably we need to have a date of birth certificate and SSC certificates. Otherwise, we have the only method is bone ossification test. So in this thing also, we have a lot of stakeholders are important in this convergence for converging all the laws. So these are the police are to record the statements under 24 of the POCSO Act in plain clothes, the police officer, and language to be used, the same language spoken by the children, the medical examination to be conducted, the frequent breaks to be given to the child. So police officers should read out loudly to the victim and then record. The child dignity have to be protected like that. And then magistrate has to record the statement within 24 hours as emphasized in the Tarkar Sivana versus Karnataka state, which is not happening, sir. The statement have to be, this is one of important ideas which I wanted to emphasize. Then medical examination is another problem. This is also not happening in 24 hours. The victims are being in queue. So the medical actual law, it is called as a medical legal emergency as per the POCSO 27 Act and also in the 164 of 184 of BNSS. So compensation. These now we have trained all the SHOs in the states, sir, through our Honorable DGP, sir. We have providing now the Form A format under POCSO rules to the victims, giving entitlement of this thing, and also preliminary assessment to report. Yeah. So this is the Child Welfare Committee. In three circumstances, we are producing the victim before the Child Welfare Committee when the accused and the victim are in the same household, because we have the most of the cases pertaining to this case, so 94% cases are on this nature. Child is living in child care institution, and when the child is without any care. So support services we are providing. Appointment of support person is there. Then child-friendly procedures of all judges, they know this. This is an important aspect, sir. We all converged today to make the child an important aspect, make the child to be free, and make the child to not to re-traumatize. All the stakeholders to converge, and there are important judgments which are there. And finally, I request, let us protect the child rights and the best interest of the child. Thank you so much. One and all.
Thank you, sir.
Thank you very much, Sri Ashok. And I will not say anything because we are already 25 minutes behind our schedule. And just 1 minute. And we have another session. Justice Vijay Sen is waiting for his session. So I will not take my 10 minutes. Just wanted to thank my panelists for raising very important issues. To Mr. Bhupati for showing us the decisions, citations, to Ms. Rajeshwari, educating us about so many different concepts, cyber crimes, child sexual abuse material. Interesting that from child pornography now we use that expression, child sexual abuse material, and because it shows that there's a shift somewhere in our thinking, that pornography, child pornography is not for our entertainment, but if we actually indulge in it, then we are liable for an offense. And to Sri Ashok for giving us a total overview of what the laws are and where to go in case you have a problem. So thank you very much, and but most of all to all of you, all my colleagues, my esteemed colleagues, my friends, Ms. Ramachandran, everyone, Mr. George, everyone in the audience I know. Thank you very much for being with us, and all the best for the next session. I'm sure that will be an equally great success. Thank you.
Thank you, Milad. and other honorable resource persons on the dais for such inspiring and thought-provoking deliberations by focusing on important provisions relating to child in POCSO Act cases along with other laws. We would like to take this opportunity to express our gratitude to Her Lordship and other honored resource persons for their generosity and kindness in gracing this occasion by felicitating them. For this,
Sir,
I humbly
just 1 minute, sir. Just 1 minute. With the kind permission, Chair, I want to tell one important judgment because what is happening is the Supreme Court frowned the practice of using the word child pornography in judgments, but still judges are using the word child pornography. Recent judgment that we should keep it in mind. They frowned it. Recent judgment, just rights for children, aliens, and others versus S. Harish and others. 2024 SEC online. Supreme Court page 2611 is its citation. Please note down. Supreme Court frowned it. They asked the courts to use the word CSEAM, 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 child sexual exploitation and abusive material. They gave such direction to the Union government also. Press is correctly using. Recently I read some articles in Hindu and Times of India. They used the word CSEAM. They did not use the word child pornography. But we are using. Please see judgment, paragraph 260, Roman 1, Roman 2. Please kindly see. Paragraph 260, Roman 1, Roman 2. There is a wonderful judgment of Justice J.B. Pardiwala and Justice Chief Justice D.Y. Chandrachud. Wonderful judgment. They frowned the practice. The government may not follow, but we have to follow. Please kindly note this.
thank you, sir.
Thank you.
Sir, now I humbly request Honorable Srimati Justice E. Tirumala Devi, Madam, Judge High Court for the State of Telangana, to kindly present a memento to Her Lordship, Honorable Ms. Justice Maushami Bhattacharya, Judge High Court for the State of Telangana, and Chairperson of the Committee to monitor the cases filed under POCSO Act. Now I humbly request Honorable Sri M.B. Ramesh Sir, Principal District and Session Judge, Asifabad, to kindly present a memento to Honorable Sri C.H.K. Bhupati, Principal District and Session Judge, retired. Thank you, sir. Now I humbly request Dr. Chetana, IPS, Women Safety Wing, to kindly present a memento to Ms. Rema Rajeshwari, IPS, Deputy Inspector General of Police, Women Safety Wing, Telangana. Now I humbly request Sri Akeshwar Rao, Joint Director, Women Development and Child Welfare, to kindly present a memento to Sri Pagadal Ashok, Additional Deputy Commissioner of Police, North Zone, Hyderabad. Now I seek the permission of the Honorable Chair to declare the session closed. Now it is time for tea break, and all are requested to reassemble for the next session at within 10 minutes. In the lawn, tea is available, sir, for participants.
sapling to Sri S. Shashidhar Reddy garu. Now I request Madam Chandana, member SCPCR, to present a sapling to Soni Kutti George, Child Protection Specialist, UNICEF. This session will focus on the international conventions and national legislations and how the child-related acts were enacted and what is the role of the government. I request all the officers please maintain silence in the session. Session has already been commenced. Please cooperate. If you cooperate, we will close the session on time. My Lord, Honorable Sri Justice Vijay Reddy garu to take up the session.
Senior Judge Justice Moshami Bhattacharya present here, other esteemed sister and brother judges, my co-panelists Mr. Shashidhar Reddy, Senior Judicial Officer, Mr. Soni Kutti George, Child Protection Specialist, UNICEF. Good afternoon. On lighter vein, I should say after lunch and high tea, as a Telangana person, I know it is difficult for all of us. And judicial officers, Monday to Friday, they have heard lawyers. Now, by compulsion, they have to hear the judges. I cannot help. Now we are here to discuss on this topic assigned to our panel, which is legal framework, international conventions, national legislations. So I hope to stick on to the time, and if I exceed, someone can remind me. So, children's right to safety is a shared global commitment. The UN Convention on Rights of Child obliges the state to protect children from all forms of sexual exploitation and sexual abuse. Now, Mr. Bhupati said not to use certain words, but because we have several stakeholders here, sorry, I did not take the names of police officers, judicial officers, retired, delegates of the dais, NGOs and other stakeholders who are present here. So let me again say it is the obligation of the state to protect children from all forms of sexual exploitation and sexual abuse, including prostitution and pornography. Similarly, ILO conventions on child labor, especially Convention number 138, which deals with minimum age, and 182, which deals with worst forms of child labor, establish a duty on governments and businesses to safeguard children from exploitation. These international standards underscore that child protection is not merely a governmental task, but a broad social responsibility involving communities, employers and all stakeholders. POCSO Act, a comprehensive law for child safety. India's Protection of Children from Sexual Offences Act, for short, POCSO Act 2012, is a watershed legislation dedicated to combating child sexual abuse. Unlike general provisions of IPC, POCSO Act explicitly defines and penalizes various forms of sexual crimes against children, closing loopholes and providing specialized procedures. For instance, penetrative sexual assault under Section 3, analogous to child rape, carries a minimum sentence of 10 years up to life and the maximum sentence extending up to life imprisonment. If the victim is under age of 16 years, the punishment increases to not less than 20 years. Similarly, non-penetrative sexual assault, Section 7, such as inappropriate touching, is punishable with an imprisonment between 3 to 5 years. While aggravated sexual assault under Section 9, for example, by police officers or armed offenders, attract at least 5 years imprisonment. POCSO Act also criminalizes sexual harassment. Example, sexually suggestive behavior with penalties up to 3 years. Sexual exploitation of children is stringently outlawed. Section 14 punishes using a child for any pornographic purpose with 5 to 7 years jail and 7 years on repeat conviction. Section 15 penalizes possession or storage of child pornography. For example, failure to delete or report such material incurs fine to the maximum of 5,000 rupees and even jail of between 3 to 5 years for commercial distribution. Importantly, Section 21 makes it an offence punishable up to 6 months jail imprisonment if anyone, including parents or caregivers, fail to report a child sexual offence or record it properly. These provisions from assault pornography to reporting make POCSO an exhaustive child protection statute far more specific and protective than ordinary IPC sections. Victim-centric and child-friendly provisions. POCSO mandates child-friendly court procedures. Section 23 strictly forbids identifying a child victim. No report in any media shall disclose the identity of a child, including his name or her name, address, photograph, so and so. Trials must be in camera. Special courts are introduced to try POCSO cases behind closed doors, allowing only child's parents or trusted person in the court. Section 24 requires that child statement must be recorded at home or a comfortable place by a woman officer not in uniform, ensuring that child does not meet the accused or get detained at night. Such child-friendly measures pioneered by POCSO and reinforced by judicial guidelines aim to reduce trauma. To sum up Act's procedural rules under Sections 24 to 28 and Section 37, etc., create a shield, supportive environment for vulnerable victims, reflecting best practices in child-focused justice. Judicial initiatives and special courts. Due to proactive steps taken by the Honorable Supreme Court of India, notably in 2019 in case of alarming rise in number of reported child rape incidents, the Supreme Court, led by the then Chief Justice of India, Gogoi, mandated exclusive POCSO courts in every district with over 100 pending cases. The court ordered that each district shall have at least one fast-track court only to try POCSO offences under a central scheme, fully funded for judges, infrastructure and support staff. More recently, in May 2025, Supreme Court reiterated this directive, pressing the centre and states to set up dedicated POCSO courts on top priority and to meet the strict statutory timelines for investigation, that is 2 months, and trial, that is 6 months. The court even appointed amicus and senior counsels to monitor implementation. These orders reflect a judicial wake-up call aimed at reducing case backlogs and signalling that society will not tolerate neglect of child abuse cases. According to the recent data, India still has huge pendency. There are about 2,39,188 cases. Out of 2,68,038 POCSO cases filed in the year 2022 and pending trial. The fast track scheme launched in the year 2019 initially set up hundreds of special courts mandating one exclusive POCSO court wherever cases exceed 100. In 2019, that was true in 389 districts. However, even now many districts lack fully functional courts. The court has publicly flagged that we are not even getting enough judges for regular courts, thereby constraining creation of dedicated POCSO courts. The Honorable Justice Supreme Court, retired Justice Bela Trivedi, noted in September 2024 that although hundreds of special courts were ordered, many are only partly established, stressing that ad hoc arrangements are no substitute for properly staffed courts. In short, Supreme Court has mandated special POCSO courts, but consistent follow-through by states is crucial. State and stakeholder responsibilities. Implementation of POCSO is ultimately a state and societal responsibility. State home departments must designate and fund these special courts, while High Court must appoint regular judges, not temporary, and ensure that they are trained in child rights issues. The Director of Prosecution and state government should also assign trained regular public prosecutor to these courts. The Supreme Court has warned that judges handling POCSO cases should not be overburdened with other work, a challenge amid India's severe judicial vacancies. Legislative and executive branches must therefore expand infrastructure and manpower. The police and investigative agencies are critical stakeholders. Under POCSO, every police officer is required to have a child welfare police officer or a special cell for children and to promptly register cases under sections 19 to 21. Officers must gather evidence quickly, especially medical and forensic samples, since delayed lab reports have repeatedly been cited as causes of trial delay. In fact, in 2019, Supreme Court directed that existing forensic science labs be made fully functional to turn around DNA and sexual assault evidence rapidly. Police must also be sensitive in interrogating children. Female officers recording statements out of uniform. This needs to be followed. Periodic training and sensitization programs for police, prosecutors, judges and community stakeholders can enhance their effectiveness, a point repeatedly urged by court and child rights group. Here I would like to emphasize one point. Normally when we see several programs and conferences organized, we give a lot of importance to all the stakeholders, police, investigation, public prosecutors, judges, and NGOs are also called. But in my personal opinion, the defense lawyers also should be the stakeholders, which we have forgotten. They should have been invited to the conferences. A lawyer has a moral obligation towards his client. As a defense lawyer, his ultimate goal is to get acquittal. And he knows he will go to the farthest extent to get an acquittal. And he should be sensitive to a trial under POCSO Act cases. IPC offences and other general law offences. You know, we got used to this conventional practice. And as judges, you know, as lawyers, you know, most of the witnesses, if you see 304 IPC, classic example, many of them are given up by the prosecution and most of the witnesses turn hostile. Now, coming to POCSO Act, if there is a offense, heinous crime like penetrative sexual assault, I can understand there will be external, internal injuries, there will be forensic evidence. But what about inappropriate behavior and sexual abuse, where child who was within four corners of a room was subjected to sexual harassment? I am not pessimistic in saying this, but as a lawyer I have seen in my 25 years of career, and as a judge I have completed five years, the police investigation in sexual abuse cases is not easy thing if you go by the, I am saying going by the convention. It's not to criticize the system. With this conventional practices, very difficult for anyone to come to the court, and even if they come to the court, and if charge sheet is filed based on sole testimony of the victim, all of us know what is the conviction rate. Police, the effective investigation is indispensable. Registering the crime and filing a charge sheet on time is not enough unless investigation is thorough. Investigation officers should avoid any lapses like missing witness statements and medical evidence that could weaken the case. Senior prosecution should vet POCSO charge sheets to ensure completeness. Importantly, POCSO makes most offences non-bailable for accused adults. Section 12(1) bars bail until charge sheeting and trial, signaling that prosecutors should generally oppose bail applications. Ensuring these cases more quickly through court sends a strong message of seriousness. The goal is trials to be completed in months, not years, so that victims and their families feel that justice is being taken seriously. Victim and witness protection measures. Victims of child abuse and their families are inherently vulnerable socially and emotionally. POCSO's provisions aim to protect them. In addition to anonymity under Section 23 and in-camera trial under Section 37, the Act and related guidelines provide special accommodations. For example, witness can testify via CCTV and behind screens, and court may allow support persons or experts to accompany the child. The National Commission for Protection of Child Rights and State Commission have issued detailed rules for supporting child complainants and witnesses under Section 39. Unfortunately, implementation gaps remain. A recent judiciary report found that over 80% of the districts lack vulnerable witness deposition centers or separate child-friendly rooms. This underscores the need for improved court infrastructure like waiting halls, playrooms, ramp access, trained staff to reduce further trauma. Now, what is the role of civil society, legal aid and statutory institutions in child protection? Beyond the statutory provisions and judicial mandates, civil society organizations and legal aid institutions play an indispensable role in effective implementation of protection of children from sexual offences. These organizations act as a bridge between law and the victim, ensuring that child's journey through the criminal justice system is not re-traumatizing. Numerous NGOs work in coordination with police departments, prosecution units and judiciary to sensitize key stakeholders. They conduct training programs for police officers, especially those in juvenile and women protection cells, focusing on child-friendly procedures, gender sensitivity and trauma-informed approaches. Many NGOs also accompany victims and their families to court, ensuring their rights are protected and they are supported with counseling, legal advice and shelter when required. Role of national and state commissions and the oversight. The National Commission for Protection of Child Rights, for short NCPCR, and its counterparts in state commissions are pivotal statutory bodies constituted under the Commission of Protection of Child Rights Act 2005. Their primary mandate is to ensure that all laws, policies and programs are in consonance with child rights framework outlined in Constitution and international conventions like United Nations Convention on Rights of Child. These commissions have given statutory authority to inspect child care institutions, juvenile homes, special courts, monitor the implementation of POCSO proceedings, investigate complaints of delay or insensitivity, recommend policy changes to the government and ministries, conduct awareness drives and legal literacy programs among children, parents and communities. In particular, commissions can appoint child welfare experts or assign support persons under Section 39 of the POCSO Act, whose role is to guide and assist child victims throughout the legal process. This plays a crucial role in restoring the child's psychological and emotional confidence. Alongside child commissions, the National Commission for Women and State Women Commissions have overlapping mandates when it comes to protection of child, especially in cases involving trafficking, abuse within families or sexual exploitation in institutions. These commissions also offer legal assistance, counseling services, shelter homes and help in rehabilitation of the victims. Legal aid and access to justice. Under Legal Service Authorities Act 1987, every district legal service authority, DLSA and state SLSA is mandated to provide free legal aid to children, particularly those from economically or socially disadvantaged backgrounds. POCSO victims are entitled to legal counsel at state expense from the stage of recording FIR through to trial and appeal. The Legal Service Authority, in collaboration with bar associations and NGOs, often conduct sensitization program and outreach programs to spread awareness about their entitlements. Supporting legislations, strengthening the ecosystem. The Juvenile Justice Act 2015 complements the POCSO framework by ensuring that even a child in conflict with law are treated with compassion and reformative principles. The Act prohibits capital punishment and life imprisonment without possibility of release for child offenders. Now, since I'm short of time, I'll just refer to the other statutes where protection is given to the children. That is Right of Children to Free and Compulsory Education Act 2019. Then other schemes of central government like Ministry of Women and Child Development, wherein they have schemes like Child Protection Services Scheme, One Stop Center Scheme, Ujjwala Scheme, Nirbhaya Fund, etc. Now, in conclusion, let me say the promise of POCSO Act is upheld not by law alone, but by interconnected web of statutory institutions, commissions, civil society and legal aid mechanisms that give meaning to its provision on the ground. The combined efforts of judiciary, executive and social sector ensure that no child walks alone in their fight for justice. Protecting children from sexual offences is a collective obligation, legal, moral and social. International norms, UNCRC, ILO, etc. set broad objectives. India's POCSO Act translates them into concrete law with stringent penalties and child-friendly processes. Yet statutes alone are not enough. The judicial activism mandating special courts, fast trials, infrastructure improvement must be matched by diligent state implementation and community vigilance. Investigators, prosecutors and judges must receive training and adequate resources so that no POCSO case drags on unreasonably. Equally, society must listen to children's voices, never ignore a report of abuse and support victims without stigma. By enacting POCSO and related laws, India acknowledges that child protection is everyone's responsibility. Now it is imperative that courts, government, police, educators, families and citizens work together in policy and practice to fulfill that responsibility. In doing so, we not only uphold the rule of law, but also safeguard the most vulnerable amongst us, ensuring a safer future for every child. Thank you for giving me this opportunity. Now, many of you sitting here, particularly judicial officers, might be knowing about our co-panelist, Mr. MCRHRD Reddy is one of the senior most judicial officers, and I request him to commence his session.
My Lord, Honorable Sri Justice B. Vijay Sen Reddy Garu, my co-panelist Sri Soni Koti George Garu, Honorable Judges of the High Court for State of Telangana, all the dignitaries assembled here, a very good afternoon. My topic should have followed Mr. George because the topics overlap. Since George will be speaking of the legislations, I will be speaking of the obligations the legislations impose on the state. But be that as it may, I will do my topic. Any gaps are there, Mr. George's speech will cover them. And I'm not going to speak of the various legislations in detail. Sir, I'll just tell you, I'm sure this side of the audience would have heard of this. I'm sure those of you who have studied law on that side would also have heard of this. HLA Hart said, oceans of ink were spilled to define what law is. Now today we are gathered here to deal with child rights. I would say similarly, as vast oceans of ink were spilled to define what a right is. Now the reason why I speak of this is rights are defined variously. They have various meanings. So for our purpose, I adopt one particular definition. That is, you have a right if you can find an authority to enforce it. Telugu, I'm sure all of you understand Telugu, right? I have a right not to be beaten. Unless my friends in khaki are standing before me, I don't have that right. I have a right to realize some money. Unless my brothers and sisters sitting here give me a degree, I don't have a right to realize it. So, as long as we have an authority that says, I will enforce your right, I will protect your right, we have a right. Otherwise, it's just paper. That is what the role of government is. I'll give you a just brief, very vague outline of how these rights came about. In olden times, in pre-modern times, there is even a debate now whether a concept called a child or childhood existed. Today we have defined terms. We say child is less than, any person who is less than 18 years. His life, we define his experience as childhood. We define a particular age group as adolescence. There is a very big debate whether such a concept existed a couple of 100 years ago. Consequently, children used to do whatever adults used to do. They would work in the farms. If the father is a blacksmith, they would work in the smithy. If he is a tailor, he would work in the tailor. He was a weaver, they would assist in the weaving. So there was no distinction between what work an adult would do and a child would do. But as time progressed, as more education started spreading, and as industrial revolution came, this distinction, the lack of distinction, what happened was, children were also employed in the factories, and you know how factories are. In the mines, they suffered hell. The best example is Oliver Twist. If you are reading, it's set up in Victorian England. It shows the fate of children at that point of time. There is another thing, there's something really called phosphorus girls, matchstick girls rather. These were girls who suffered deformity because they handled phosphorus for making matchsticks in factories. Seeing this in Victorian England, they enacted the Factories Act, regulating the age at which children can be employed. As times progressed, as conception of rights, as conception that human beings inherently have rights have come, so also various groups of our society, women, colonized peoples, children, their rights have been recognized. So we had in 1925 the Geneva Convention of Declaration of Rights. In 48 again United Nations declared the rights and again adopted it as the Child Rights Convention. This is the vague history of it. But then if you read the Child Rights Convention, Mr. George will deal with it. Every article says the state parties shall do this, state parties shall do this. Who are the state parties? All of us sitting here are the state parties. See, we are representatives of the state. We are the hands of the state. For the Child Rights Convention to operate in Telangana, we are the persons who have to do it. What the Union of India, that is Indian government and the state governments do to perform or to comply with the obligations under the conventions is they would enact the legislations. The Juvenile Justice Act, the Child Rights Protection Commissions Act, Child Marriage Prohibition Act, amendments to the Factories Act, POCSO Act, all these things come. But then, without the state machinery, they are just words, they are just letters. They have nothing to do. So what is the role of state? State controls the purse and the sword. So state has to invest it in creating the infrastructure. It has to use its word to enforce them. Then children have rights. So sir, now I am sure we are all working in the system. We know how the system works. Since I have worked on the judicial side, I know what infrastructure defects we have on the judicial side. Juvenile courts are manned by magistrates who are not regular, they are rather regular charge of that court. They attend to it at the maximum 2 days in a week. There are requirements of the juvenile code that every child has to be, they have to be, how do you say, they should, a clinical psychologist should attend to them, especially where the heinous case offences are alleged against them. I ask my colleagues, they say, sir, there is no clinical psychologist. We don't have a clinical psychologist to whom I can send the child for analysis, for a examination. When I was in MCRHRD, I was told the observation home was closed and all children were shifted to Kachiguda, the observation home, and I'm not sure, near Kachiguda. Now from Kachiguda to MCRHRD is about more than 100 kilometers, if I'm not wrong. So if a child has to be produced, they need an armed escort from Hyderabad city to MCRHRD. So children were not produced. POCSO courts. The first time I had experience with POCSO cases was when I was posted as Metropolitan Sessions Judge and First Additional District Judge of Visakhapatnam. We have a joke among ourselves, First Additional District Courts are like Swiss knives. The reason is, as Metropolitan Sessions Judge Visakhapatnam, I had 17 different designations. I was the special court for NDPS, POCSO, Electricity, Marine Act, PMLA, Human Rights Court, whatnot, 17 designations. And my pendency was about 2,300, out of which 1,125 were NDPS cases, 600 civil, 600 IPC, 74 POCSO, and about some miscellaneous cases of the rest of it. I had 625 under trial cases because, as you know, Visakhapatnam is the production center of ganja, and once a person gets caught in ganja case, he is not going to get a bail. So I had 625 under trials, every day 50 persons extension of remand, 25 to 30 bail applications, and at any given point of time 30 to 35 under trial cases. Now, what am I supposed to do with these POCSO cases? Right, I did try, because when I took it, I looked at the act and it says within 90 days, within 10 days or 30 days I have to record PW1's chief. So I said, okay, fine, let's do it. But among all that, that's the fate of all our courts. Now, when Act says you have to establish a special court, that requires a special court, it requires a special prosecutor. I didn't have a special prosecutor. I had one prosecutor who is a good man because he cooperated with me with the punishing trial schedules I fixed, but he was also the deputy director or joint director of Visakhapatnam, so he had his own administrative work. Still he worked. He cooperated, I was able to do it. Sir said defense councils. When I fixed schedules, luckily in Visakhapatnam, the defense councils did not take adjournment. They cooperated. On the day I fixed, trials were done. The reason it worked is people cooperated with me. The reason it worked is the infrastructure that I had was okay. I didn't have a special place to hide the accused, to all that, but we managed somehow. But then this will not work in the long term, and it hasn't worked. I'm sure all of you are aware it has not worked. So the role of government and role of court is that we should make these things work. We should see that children get these rights. They will only get the rights when we enforce those rights, when we invest in the infrastructure for enforcing those rights. That is what the government should do. There should be a full-time magistrate for juvenile courts. There should be special courts. Now, I have one more difficulty with special courts. Visakhapatnam, as you all know as well, is a huge district, and agencies and all that. When I was in MCRHRD, at that point of time it was divided into 3 districts. Erstwhile MCRHRD, the Siddipet to MCRHRD is about 100 kilometers. So special court in MCRHRD for a victim in Siddipet is as good as going to the moon. Then we established fast track courts in the talukas, in the stations. That is a much better development. That's what is required. Special court by itself, it imposes an unreasonable burden on the police and prosecution, because victims will be distributed across the district, but the court will be far away from them. That has to be answered. Even now, I'm sure my friends on this side of the audience would identify atrocities against women courts. They are all in the headquarters. Victims, earlier, the nearest senior civil judge court, which was assistant sessions judge, used to deal with them. Now, all the cases go to the headquarters in one court, and victims have to travel across the district to that court. So now, did it make things better or did it make things worse? And sometimes, because of shortage of judges, those courts were left vacant. So those are the things that are required, sir. The main things, like as I said, government creates all this infrastructure. It has to invest in it, invest in the policy. And one last thing is, we have to understand what children go through. As adults, we forget our childhoods. That also creates difficulty in designing policies and institutional mechanisms for dealing with children. That is also one role government has to fulfill. That is also one role all of us here have to do. So thank you, sir. Thank you for the opportunity.
I request Mr. Kuti George to start this session.
Honorable Justice Vijay Sen Reddy Garu, Shashidhar Reddy Garu, thank you so much. I think good evening, and a smile please. Come on, yeah. This is like very boring to be sitting like this. Can I play some cards? No problem. No, if I play, you will have gambling act also coming in. How many how many of you have seen playing cards? Everybody. How many cards are there in a pack? 52. Why you forget 2 of my photographs here? How many are there? 54. Okay? Just to tell you, yeah, 2 jokers are there. That's why I said 2 of my photographs. Yeah, 54. Actually, in UNCRC, UN Convention on the Rights of the Child, which defines what rights of children and what state obligations are, there are 54 articles. And there are these 2 jokers. What are the speciality of jokers? It goes with everybody. So the most important thing about the UNCRC is that you always are governed by two basic principles. The first basic principle is the best interest of the child. The best interest of the child. The second is the right to participation for the child. The CRC defines non-discrimination. I'll come to non-discrimination and others in 2 minutes. But this is the essence of universal declarations and CRCs and conventions, is to give a guideline. And most interestingly, I don't think I'll go into a PowerPoint presentation to make things complicated for you. Let's make it very simple. The most important thing in any action that we do, we are governed by certain basic principles. Basic principles. Now, defining those basic principles, from Beijing rules to Riyadh guidelines to all international conferences, meetings, have done all that. And do we have anywhere set of principles which needs to govern our action listed out? The guiding principles of our action? Any legislation? We've been talking legislations. Which ones? The JJ Act has a full chapter on the basic principles. And POCSO, let me tell you, on the object of the conference that is happening today, POCSO has nothing to do. Rehabilitation and reintegration of the child does not happen in POCSO courts. It does not happen in POCSO courts. The rehabilitation, reintegration is moved to the Child Welfare Committee, who has the responsibility to plan the rehabilitation program. Therefore, our discussions in any of the forums becomes meaningless because we go on looking at the act, the sector, what section, what, no. The basic principle comes from the best interest of the child. The presumption of innocence when it is a case of child. I wish you had that, just put that slide on the, just make sure that we understand that there needs to be guiding principles which will take us to where we are. And the fact that, go to the next. Go, oh. Okay, and it is very important that we realize that it is not going to be governed by the legislations, it is going to be governed by these principles which are listed here. And I will just go to the fact that after 1989 the CRC came. In 10 years' time we came with an optional protocol because we saw the CRC was not sufficient enough to deal with issues of sexual abuse. Then today we heard about the CSAM, the new word which is coming up. And it is an evolving, the most dynamic thing today is the internet space. And therefore the responses need to be there, so everything is happening. Last year and this year we have the Supreme Court and the NHRC giving guidelines on what to do with CSAM. We are working with the state to make sure that we have some state guidelines and action points. And therefore it is important that we realize what we do in terms of like what is it that we look at the basic principles, which I thought I'll just show you. Just here, the best interest of the child is defined by the views of the child. The best interest definition, how do we really make it happen? So you need to listen to the child. And within the legislations, we have a lot of spaces in terms of MTP, in terms of whether you want to medical examination. There are provisions which are based on the views of the child. There is the necessity to look at the child's identity. We are talking about tribal children. We are talking about children from all around. So we need to look at the culture, the identity of the child, vulnerabilities of the child, and preservation of the family. The family as the most important unit. But then even there, if the child wants to remain with the family or not, is something that the child will decide when there is a POCSO case, and that is where it is important for us to realize that the best interest of the child is the most important thing that we need to do. Look at the guiding principles. I am not talking from anything. This is under Section 3 of the JJ Act. It's a full chapter. And let me tell you, I was interviewing people for the JJBs and CWCs. Out of the 600 people we interviewed, not even 3 knew about the guiding principles. Now, all of us sitting here have been in this business for donkey's years. If we are not governed by these basic principles which are there, and if we don't start our judicial training programs, starting with these mandates which are there, which should guide every action we take. And therefore, it is necessary that we understand and move forward in this direction. I'm just not going into the details of what needs to be done, and what is the objective of to these meetings. Why are we called us all together here? I'll just go to that and then finish. I'm just skipping all these. Yeah, just to look at these objectives. Why are we here? The business is to look at required policy reforms. Now, the policy reforms, I think I just loved what was said by you, because holding a mirror to yourself and being realistic about what is happening is the most important aspect of starting. If you don't say the truth, if you don't say what is the problem, we will never be able to solve it. And I think articulation and honesty is the first thing. And in terms of the policy, I think the best interest of the child, and how do we bring these focus onto the best interest? How do we bring the focus of our trainings into these aspects where these guiding principles are there which should guide us? Which is like, which is the most important thing. The object of the legislation, if this is the most beautiful thing about the act, is that why we say POCSO and JJ needs to be read together, because POCSO's role is limited. The rehabilitation role is under the JJ Act, and it needs to be governed here by these principles. And therefore, how do we bring that in our discussion? How do we bring those in our policies becomes critical. The second is interagency cooperation, collaboration. I think you heard what Bharosa is doing. You heard what She Teams is doing. You heard what is happening in this state. Mushmi was here. She is doing this regular review, monthly reviews with these people, making sure things are moving. You have the commission, Children's Commission, who is mandated to be doing such functions everywhere. And interagency coordination does not happen sitting like this. This is upper-lower relationship. I am just talking to you. You are not challenging me. We need to have settings where we sit around, put the problems, hold the mirror to ourselves, say the problems up front. Then collaboration and working together becomes a reality. And that is the most important thing. And I think before we go into the last one, I have this to show. The whole dimension of human rights, child rights, start with the human dignity of the child. The dignity of the child in terms of when happens discrimination, abuse, exploitation, silences the child, dignifies the child. It does the maximum harm. Any sexual offense does the maximum harm, which takes ages for the child to come back. And there, for those voiceless, we are saying we need to rehabilitate, reintegrate, and give them, restore them back. And that restoration process is not an easy job. And POCSO courts do not do anything about it, because your role does not have anything to do with those. And that is done by CWC and others, who needs all support in making sure that the child from voicelessness comes back to a voice, gets back the voice, being natural, being able to survive, thrive, and go ahead in life. And I think it is not to learn from international experiences, it is in making sure that our good practices of Bharosa, what we are doing, becomes a national, international good practice. The challenge before us is to bring people to take it to that level. And I take that challenge with you today to make sure that we are able to make a difference in the life of the children, and not just as POCSO court judges, not just as police officers, but we as a collective, staying together because the child needs it. The offenses, sexual offenses, does maximum damage to children. To revive them, it just does not work with one or two, but with all of us. And together, let us make this workshop a success and let every child enjoy their rights. Thank you so much.
Thank you, Mr. George. So we have heard Mr. Shashidhar Reddy, who has given good narration of child rights and historical exploitation of children in various forms, the obligation of all the stakeholders, and he has shared his personal experience and pointed out deficiencies in the system like lack of clinical psychologists, overburdening of special courts dealing with POCSO cases, and practical difficulty he has faced when he was district judge of Vizag and Sangareddy. And Mr. Sonikuti George has enlightened all of us about the importance of JJ Act and rehabilitation. His PowerPoint presentation on best interest of child and necessity of all the judges to upgrade their knowledge in JJ Act, which are in tandem with the POCSO Act, I think should alert all the stakeholders, especially the judges who are presiding the POCSO courts. And Mr. Kuti George's presentation on dignity of child, and also the importance of restoration and rehabilitation of the child, all needs to be paid attention at all levels. So to conclude this session, let me tell all of you present here, we are short of specialists and experts. All of us know. We have infrastructure, we have funds, we have policy makers, we have everything, but we are lacking specialists and experts. There are some things which I cannot elaborate, but when we are notifying posts for appointment of judges, you know, there are many applicants, but it has become very difficult for us to select them. Outside there is a criticism that there is lack of employment. But let it be an eye-opener for all of us. There are many sources of employment, but people got used to less work and more money. I don't know whether this is a problem in Telangana or everywhere in India. People want less work, a job without any expertise and regular salary. We need to change our attitude. We have to upgrade our skills at all levels. We need experts, we need judges. Now we do not have separate cadre for judges dealing with POCSO cases. Separate cadre is a very difficult task. However, in my personal view, there should be special courts and dedicated courts to deal with POCSO cases. For example, if there are 300 cases, the judge should deal only with the POCSO cases. Otherwise, you will not achieve the objects of this POCSO Act and GJ Act. And if the disposal rate is good and it is less than 100, depending upon the nature of work and the trial schedule, the judge can be assigned other works. But if the cases are more than 150, according to me, there should be special dedicated courts to deal with POCSO cases. And let me appreciate the Telangana police force who have received appreciation from all quarters, including the Honorable Supreme Court in operating these Bharosa centers. These Bharosa centers in Telangana have created a great space for women protection, and it is a matter of pride for all the Telangana people that Supreme Court has taken cognizance of this and said that this Telangana model should be followed in other states. So I congratulate all the police officers present here. So thank you very much for participating in this session, and even after lunch and tea break. Thank you.
Esteemed guests. Now, we would like to take this opportunity to express our gratitude to His Lordship and other honored resource persons for sparing their valuable time and kindness in gracing this occasion by felicitating them. For this, I humbly request Honorable Sri C.H. Ramesh Babu, Principal District and Session Judge, Jaishankar, Bhupalpalli District, to kindly present a memento to His Lordship, Honorable Sri Justice B. MCRHRD, Judge, High Court for the State of Telangana. I humbly request Honorable Srimati G. Neelima, Principal District and Session Judge, Medak District, to kindly present a memento to Honorable Sri Shashidhar Reddy, Chief Judge, City Civil Court, Hyderabad. I also humbly request Srimati Chandana, Member SCPCR, to kindly present a memento to Sri Sonikuti George, Child Protection Specialist, UNICEF. Now I seek the permission of the Honorable Chair to declare the session closed. Thank you. Thank you, Miller. And the session is continued. There is no tea break, please. Due to lack of time. I, on behalf of State Legal Services Authority, Hyderabad, Women Safety Wing, Telangana State Police, in collaboration with Women Development and Child Welfare, Telangana State Legal Services Authority and UNICEF welcome all the honorable high dignitaries, invited guests, participants present here, ladies and gentlemen, to this consultation meet for technical session 3 on providing free legal aid to the child victims under Legal Services Authority Act 1987, role of State Legal Services Authority in disbursing the compensation schemes of NALSA for the protection of children. It is now my honor to invite Honorable Sri Justice P.R. Madhusudan Rao, Judge High Court for the State of Telangana, to kindly adorn the dais. Milord, please. Now I humbly request Honorable Sri G.V. Subramaniam Sir, District and Session Judge retired and former Member Secretary, Telangana State Legal Services Authority, Hyderabad, to kindly adorn the dais. To begin with, I humbly seek permission of Honorable Chair to declare the session as open. Milord, please. Thank you, Milord. The session is declared as open. Every great event begins with a heartfelt welcome. Milord. Milord, please. Sapling.
Sapling? You can give it afterwards.
Every great event begins with a heartfelt welcome. To do the honors, may I now request Srimati Lakshmi Sharda Madam, Principal District and Session Judge Suryapet, to kindly present a sapling to Honorable Sri Justice B.R. Madhusudan Rao, Judge High Court for the State of Telangana, Hyderabad. I also request Honorable Sri Boya Srinivasul Sir, Principal District and Session Judge, to kindly present a sapling to Honorable Sri G.V. Subramaniam Sir. As our speakers make their way to the stage, I urge each one of you to open your mind to new ideas, engage actively, and soak in the valuable insights. I now request Honorable Chair to commence the session. Thank you, Milord.
A very good evening to one and all, and welcome to the State Level Stakeholders Consultation Meet 25 on Voice for the Voiceless, Rights and Protection of Children of Sexual Abuse. I'll see that I may not receive any slip from the Member Secretary and I complete this thing within 10 minutes. The reasons for forming the Legal Service Authority is to implement Article 39A of the Constitution, which directs the state to provide free legal aid to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability, and to systemize the institutionalized legal aid services that were previously ad hoc or run by voluntary organizations, to make justice more accessible and reduce the burden of courts through alternative mechanisms like Lok Adalat, and to uphold the principles of justice for all, not just for the privileged. The Supreme Court of India, in a series of judgments in 1970 and 1980, like Husainiara Khatun versus State of Bihar, emphasized the importance of legal aid as part of fundamental rights under Article 21. Several critical debates took place between 1950 and 1980, both in legal circles and government policies forums. Legal aid, a right or a charity? One major debate was whether legal aid should be considered a fundamental right or a welfare service. Progressive judges like Justice P.N. Bhagwati argued that legal aid is part of the fundamental rights of equality under Article 14 and Article 21. And others feared that such a right would place unsustainable financial demands on the state. Should legal aid be administered by the judiciary or to maintain neutrality or by the executive for efficiency? The final decision favored judicial leadership to preserve impartiality and public confidence. Why legal aid? There were disagreements over how to define the weaker sections of the society. Some favored broad inclusions and others argued for a more restricted income-based approach. And the Federal Neutrals of India led by discussions about how much control the central government should have versus allowing the state authorities in implementing the legal aid programs. The formation of legal service authority system took place in phases involving key reports, committees and legislative actions. Law Commission report, 14th Law Commission report of 1958 and under MCRHRD was the first to recommend systematic legal aid. Later, 42nd and 48th report further emphasized legal aid as essential to justice. Justice Krishna Iyer Committee 1973, this committee led by Justice V.R. Krishna Iyer emphasized that the poor must have the same access to courts as the rich, and the state must be responsible for ensuring it. The formation of CILAS 1980, that is the Committee for Implementing Legal Aid Schemes, was created under Justice P.N. Bhagwati. It proposed a nationally coordinated legal aid structure and played a vital role in spreading Lok Adalats and legal literacy. Legal Service Authority Act 1987, passed by the Parliament to give statutory background to legal aid schemes, and it created the National Legal Service Authority and its counterparts at the state and district level. The Act was implemented in 1995, delayed due to logical and financial concerns. Justice P.N. Bhagwati often called the father of the legal aid movement in India. And what is the genesis of Legal Services Authority system? In 1958, 14th Law Commission report was given. The significance is that first official recommendation for legal aid. And in 1973, Justice Krishna Iyer Committee, legal aid as a constitutional responsibility. And 1976, 42nd Constitutional Amendment added Article 39A, free legal aid, made a directive principles. 1980, formation of CILAS, Justice Bhagwati coordinated national legal aid schemes. 1987, Legal Service Authority Act passed, provided statutory basics for legal aid institutions, and 1985, Act is enforced, NALSA is established, full implementation of structural legal aid system. Now, the session deals with providing free legal aid to the child victims under Legal Service Authority Act 1987, role of State Legal Service Authority in distributing the compensation, schemes of NALSA for the protection of children. I think this session will enlighten you about the Legal Service Authority Act, and I request Mr. Subramaniam to take over the session.
Honorable Sri Justice Masoodan Rao Garu, the chairperson of the session, most respected judges of the Honorable High Court for the state of Telangana, sitting in the audience, Honorable Minister who has arrived just now,
and sitting in the audience, and respected police officers, respected judicial officers, and other stakeholders. Because we are running short of time, I do not want it to come in the way, because I am told that the Muharram processions are going on, so you may have traffic problems, transportation problems. Therefore, I also, while sailing with your chair, would like to conclude the session at the earliest. But it becomes an imperative for me to deal the subject, at least cursorily. As we all know, section 2Y of BNSS defines the victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person, and includes the guardian or legal heir of such victim. Why the definition of the victim has included the guardian is the aspect which requires an appreciation. We all know that particularly in sexual offences, when the victim suffers mental and physical trauma, there should be somebody in the family to attend to their needs. And obviously they have to have many sacrifices to meet their requirements and to bring them out of trauma and to have some reparation. I recollect one such incident where a 12-year girl was sexually molested, and her mother was an employee in central government. I may impress upon you that the child underwent such a traumatic situation that she was afraid to come out of the house. She was afraid to see any male person. Even she was afraid to look at her own father. Such was the situation. In such situation, the mother was compelled to go on long leave for a period of 2 years and to take care of the child and see that she would come out of this traumatic condition. She was taken to psychiatrist, etc. So it is the guardian. The victim does not mean the one who has suffered the sexual assault directly, but it includes the guardian of the victim also. Therefore, with the wisdom of the lawmakers, with the wisdom of the Honorable Supreme Court, in view of the various decisions of the Honorable Supreme Court, the definition of victim has been expanded, and it includes the guardian and legal heir of such victim. I once again say that why the guardian has been included. Because our topic today is to deal with the compensation payable to the guardians or victims. Many a time the victims may not come forward to submit an application to either DLSA or SLSA. It is their guardians who will be coming forward to submit the application. Such applications have to be decided by the DLSA or MLSA respectively, considering various conditions, which I would narrate later. A sexual assault victim means a female who has suffered mental or physical injury or both as a result of sexual offense, including sections 74 to 79, 64 to 70 as per the new BNS. And who is the dependent? Because the subject is with regard to disbursal of the benefits of the scheme. It is necessary for me to define the dependent also. Who is dependent? Dependent includes husband, father, mother, grandparents, unmarried daughter, and minor children of the victim as determined by the State Legal Services Authority or District Legal Service Authority on the basis of the report of the subdivisional magistrate of the concerned area or SHO or investigating officer, or on the material placed on record by the dependents by way of affidavit or on its own inquiry. Here at this stage, in my little experience when I was working as Member Secretary of State Legal Services Authority, I have come across that whenever lump sum amount is to be paid to the victim or their dependents, as per the schemes promulgated or framed by NALSA or central government, the unfortunate situation I have seen is that several dependents were coming forward to claim the compensation, leaving apart the safety, security and other things which the victim desire. Then in such situation, SLSA or DLSA is depending on the inquiry to be caused by the investigating officer or the particular revenue authority, subdivisional magistrate. In my experience, I say there is inordinate delay in deciding as to who will be the dependent to receive the compensation. Unfortunately, in few cases, even Guardians and Wards Act OPs were filed to determine who will be the legal heir. Who will be the legal heir to receive the compensation on behalf of the victim. Such situation need to be answered by us, because the last clause of the dependent defines that it can be by way of an affidavit submitted by the dependents or on its own inquiry. So whenever such application is submitted, my appeal to all my stakeholders or all my members of DLSAs and the Honorable Member Secretary of SLSA is to determine the dependents as expeditiously as possible. Of course, the rules and schemes also contemplate that it should be decided within 60 days. So there is inordinate delay with regard to that. Then with regard to eligibility of compensation, a women victim or her dependent or dependents, as the case may be, shall be eligible for grant of compensation from multiple schemes applicable to her. While assessing the compensation awarded earlier under section 357 is supposed to be excluded. Recently, a scheme has been framed by the central government and NALSA also, which is called as Compensation Scheme for Women Victims and Survivors of Sexual Assault and Other Crimes. In the said scheme, fund does mean a victim compensation fund constituted under the state compensation scheme. Central fund means fund received from CVCF scheme 2015, and women victim compensation fund means a fund segregated for disbursement for women victim out of state victim compensation fund and central fund. We all know that probably many of the stakeholders would know that in the recent past the Telangana state government has enhanced the upper limit of the compensation to be payable to 10 lakh rupees for various offences which have been enunciated in the schedule. So of course for various offences some particular slab has been fixed. I request the stakeholders to go through that schedule. And humbly request the Panchakshari Garu, the State Legal Services Authority, to circulate the GO that has been issued by the state government and other concerned material with regard to the payment of compensation. So whenever a recommendation is made by a court for compensation, the DLSA or SLSA, as the case may be, shall decide the quantum of compensation to be awarded in the scheme referred earlier. And the procedure for submitting the application claiming the compensation is, it is mandatory to report FIR. Unless the FIR is issued, neither the victim nor the dependents will have any right to submit an application claiming the compensation. The SHO shall mandatorily share a soft copy or hard copy of the FIR immediately after registration with the SLSA or DLSA. The earlier speaker was saying, some George, that there are many latches where an FIR is registered either against the child or when there is a victim. That FIR is not being communicated to DLSA forthwith. So once again my appeal to my DLSA secretaries is to foresee that whenever the FIR is registered, it would reach to you at the earliest within 24 hours. An application for award of interim compensation or final compensation can be made by victim or her dependents or the SHO concerned. See the beauty of the act, that even the SHO also empowered to submit an application for seeking compensation, because some immediate needs have to be met. Immediate needs have to be met when a sexual assault is made against a minor child victim, because she needs some medical assistance, she has to be taken to the hospital, she requires some treatment, etc. Therefore, even the SHO is empowered to submit an application to the DLSA or SLSA, as the case may be, for seeking interim compensation also. There are provisions under all the schemes formulated by NLS and NALSA that interim compensation also can be decided by DLSA. The place of filing the application for compensation is either DLSA or SLSA, and the secretary has to thoroughly go through the schemes announced by NALSA and the central government, and the DLSA secretary is supposed to decide the quantum of compensation to be paid. And there is a special provision for acid attack cases. When I was working in Madanapalle long back, of course during those days these good provisions were not available. A beautiful girl fell in love with somebody, and because he came to know that somebody is also loving her, one ill-fated day he has taken her to a park and he poured an acid on her face. The beautiful girl completely devastated, completely ruined. How much compensation would really compensate? I have taken cognizance under section 307, but initially it was 326A or something. I have taken under 307 and tried, and I gave conviction for 7 years, but the victim and her family members were not allowing me to go out of the chamber. They cornered my chamber and they said that he should be hanged till that, or he should be imprisoned for life. The section doesn't warrant at that time. So as far as acid attacks are concerned, there is criminal injury compensation board. There is a criminal injury compensation board consisting of the principal district judge, SP, and the district magistrate, civil surgeon and CMO of the district. So all these authorities can decide the compensation payable to them. I have already received a chit that I should complete. Cursal, if speedily, I'll just refer to the factors to be considered while deciding the compensation, okay? That have been mentioned in the probably the material supplied to you, but to have an overview that, to know that. The gravity of the offense and severity of physical or mental harm or injury suffered by the child is the paramount consideration. The expenditure incurred are likely to be incurred for medical treatment. Then loss of educational opportunity, loss of employment as a result of offense, the relationship of the child with the offender, whether the abuse was a single isolated incident or took place over a period of time, whether the child became pregnant as a result of the offense, whether the child has contracted any STD, whether the child contracted HIV or any other disability suffered by the child, and the financial condition of the child, and any other factors that can be considered by the DLSA are the points to be considered while deciding the quantum of compensation. Finally, because my subject also says that I am supposed to make you know the different schemes announced by the NALSA, I'll just let you know. There is one child-friendly legal services for children scheme 2024. NALSA child-friendly legal services for children scheme 2024. I request all of you to go through the material that will be furnished by the member secretary. Then second scheme is this particular scheme has taken into consideration the latest decisions rendered by the Honorable Supreme Court and the developments that have taken place, and by overriding the earlier schemes called NALSA Child Friendly Legal Services to Children and Protection Scheme 2015, Legal Services for Differently Abled Children Scheme 2021. By going through the loopholes of those two schemes or unanswered aspects of those schemes, this particular scheme which I just now read, that is NALSA Child Friendly Legal Services for Children Scheme 2024 has been announced. Please go through the whole scheme, so that it will be very handy for you while deciding the quantum of compensation. There are 5 other schemes which have been framed by the central government and NALSA. They are the National Policy for Children 2013, the Mission Vatsalya scheme for 2022, Model Foster Care Guidelines 2024, Scheme for Care and Support to Victims under Sections 4 and 6 of POCSO Act 2012. Finally, this NALSA's compensation scheme for women victims, survivors of sexual assault and other crimes 2018. In view of the paucity of time, I may not consume your time, but I just finally conclude, because we, the judicial officers, while teaching in the Judicial Academy, we have the habit of telling 1 or 2 citations, so that we will have some sight while deciding as to how to answer the particular issues. All the stakeholders, particularly judicial DLSS, may kindly note down these 2 decisions. 2013 Part 6 SEC 770, Ankush Shivaji Gaikwad versus State of Maharashtra. Number 2, 2015 Part 5 SEC 197, State of MP versus Mehta. Finally, 2018 SEC Online 2772 Nipun Saxena versus Union of India. All these decisions I request the learned members to go through and come to the needy, come to the rescue of victims, and all said and done, whether the schemes are being properly implemented or not, I will leave to the discretion of my brothers and sisters. Thank you, one and all.
Closing remarks.
Sri G.V. Subramaniam Garu, he is a retired district judge and a former member secretary of Telangana State Legal Service Authority. He has taken us to the BNS, different provisions of BNSS and the definitions of dependent, and how the compensation has to be dealt with by the State Legal Service Authority and the District Legal Service Authority, and moreover the mandatory provision that FIR should be given at the earliest, so that the victim can get the compensation, either interim or full compensation, whatever it may be. And he has also dealt with the practical difficulties faced by the legal service secretaries in respect of delay in receiving the compensations and the eligibility, multiple applications filed by the persons to claim the compensation, and also taken you to the latest schemes of NALSA and the earlier schemes of NALSA, and the upper limit of 10 lakhs compensation to the victim for different kinds of offences, and also about the board and the factum of consideration to be decided while granting compensation. And finally, he has fulfilled his desire by quoting 3 judgments of the Honorable Supreme Court. And with this, I hope that this session might be helpful to all the stakeholders, as new schemes have come into play from 2024. With this, I thanks one and all for your patience hearing.
Thank you, my lord. Now, for all of you have to excuse me for retaining you all for 10 more minutes. In the audience, the Honorable Minister, Panchayat Raj and Rural Development, Women and Child Welfare, Telangana State, Honorable Srimati D. Anasuya Sitaka is present. Madam, I request you to come on to the dais. Since the Women Development and Child Welfare is one of the organizer of this consultation meet 2025, actually Madam has to participate in the valediction ceremony, but due to some unavoidable circumstances, Madam is going to visit Madam's constituency. So that is why Madam wanted to attend the consultation meet to address you all. In spite of Madam's busy schedule, Madam arrived here. Madam, now I request Madam Srimati D. Anasuya Sitaka to address the participants.
A warm good evening to all respected High Court judges and district judges, state legal cell authorities and police officials and Women and Child Welfare Department officials, SCPR members, CWC members and all other esteemed dignitaries present here. It is a great honor to welcome you all to this occasion. Your presence here signifies the collective commitment to justice, dignity and the role of the strengthen the very foundation of our democracy. In this very spirit, we must confront one of the most pressing challenges of our time: sexual violence against children and women. It is a deeply disturbing issue that shakes the moral and social fabric of our nation. Recognizing the gravity of such acts, our government has responded with seriousness and urgency and compassion, ensuring that justice is swift and support to survivors is unwavering. We had stood firmly by the victims, providing immediate support, including covering their medical expenses entirely through government funds. Offenders were arrested without delay and strict legal action was initiated. I am proud to share that in nearly 90% of such cases, the culprits were convicted and sentenced to rigorous imprisonment, ensuring justice for the victims. To further strengthen victims' support, we are setting up a green channel mechanism to provide compensation to POCSO victims without bureaucratic delays. No survivor should suffer again by being caught in the red tape of the system. At the same time, we have gone behind surface level actions to identify and address the root causes of sexual violence. Investigations by our police department revealed that a significant number of these cases were linked to substance abuse, particularly the use of ganja. Therefore, under the leadership of our Chief Minister A. Revanth Reddy, the Telangana government is taking stringent measures to eradicate drug abuse. A dedicated narcotics division has been established within the police department. Aggressive crackdowns are underway on the transportation, sale and use of ganja and other drugs. So actually ఇక్కడ జరిగేటువంటి చాలా ఇష్యూస్ అంతా చాలా చిన్న పిల్లల మీద జరిగే సివియర్ అటాక్ అండ్ రేప్స్, మర్డర్స్లో ఎక్కువ ఈ డ్రగ్స్ అండ్ ఇది ఎక్కువ కనిపిస్తుంది. దాన్ని వాళ్ళు తీసుకున్నటువంటి వాళ్ళే ఎక్కువ కనిపిస్తున్నారు. మేము చాలా కేసెస్ను వెళ్ళినప్పుడు, విక్టిమ్స్ దగ్గరికి వెళ్ళినప్పుడు చిన్న చిన్న పిల్లల మీద జరిగినటువంటి రేప్స్ కానీ, మర్డర్స్ కానీ, లేదా ఓల్డ్ ఏజ్ ఉమెన్ మీద జరిగేటువంటి అట్రాసిటీస్ కానీ ఎక్కువ డ్రగ్స్ అడిక్టెడ్ పర్సన్సే ఇందులో ఉంటున్నారు. సో దాని మీద ఈనాటి మా గవర్నమెంట్ కూడా బాగా ఫోకస్ చేసి నార్కటిక్ డిపార్ట్మెంట్ను కూడా స్ట్రెంథన్ చేయడం జరుగుతుంది. అధికారులను కూడా ఎక్కువ ఐడెంటిఫై చేసి ఎక్కువ ఫోకస్డ్గా వర్క్ చేసే విధంగా మరి సీఎం గారు దృష్టి పెట్టడం జరిగింది. మేమంతా మా ఉమెన్ అండ్ చైల్డ్ డిపార్ట్మెంట్ నుంచి కూడా మేము చేస్తూ ఉన్నాం. సో విక్టిమ్స్ ఎవరైతే ఉన్నారో జస్టిస్ అనేది డిలే అవ్వడము, లేదా చాలా చాలా చోట్లకు తిప్పడము, వచ్చినటువంటి వాళ్ళే బాధతో వస్తుంటారు. కాబట్టి వాళ్ళని ఎక్కువ డిలే చేయడము, ఎక్కువ ఇబ్బంది పెట్టే విధంగా ఆఫీసర్స్ బిహేవియర్ ఉంటే ఇంకా సఫర్ అవుతూ ఉంటారు. సో కోర్టు జడ్జెస్ కావచ్చు, పోలీస్ ఆఫీసర్స్ కావచ్చు, లేదా గ్రౌండ్ లెవెల్లో ఐడెంటిఫై చేసేటువంటి మా ఉమెన్ అండ్ చైల్డ్ డిపార్ట్మెంట్ కావచ్చు, ఖచ్చితంగా ఒక హ్యుమానిటీతో, మానవతా దృక్పథంతో ఎక్కువ దాన్ని అఫెక్షనేట్గా మనం వాళ్ళను రిసీవ్ చేసుకొని వాళ్లకు మానసికమైనటువంటి స్థైర్యాన్ని, ధైర్యాన్ని, అదేవిధంగా వాళ్ళు ఫేస్ చేసినటువంటి ఆ ఇన్సిడెంట్ను యువతులతో పోల్చి చూస్తాం. కాబట్టి ఈ సమాజంలో ప్రతి ఒక్కరూ, మహిళలు ముఖ్యంగా, పిల్లలు సగర్వంగా తలెత్తుకొని స్వేచ్ఛగా తిరగగలిగేటువంటి వాతావరణం రావాలి అంటే మరి నిందితులకు ఖచ్చితమైన కఠినమైన శిక్షలు సత్వరమే జరిగితే కొంత ఆ నమ్మకం అనేది వస్తుంది. ఏది మహిళలకు, పిల్లలకు, బాధితులకు. సో ఆ బాధితులను ఆదుకునే విధంగా ప్రభుత్వం నుంచి మేము కూడా అన్ని రకాల చర్యలు తీసుకుంటాం. కానీ ఆఫీసర్సు, తీర్పులు చెప్పే జడ్జెస్, మరి అదేవిధంగా వాళ్ళకు భరోసానిచ్చే ఉమెన్ అండ్ చైల్డ్ మా డిపార్ట్మెంట్, మనం అందరం కలిసి ఒక కుటుంబంలో, మన ఇంట్లో ఒక పాప ఉంటే ఎట్లయితే మనం వాళ్ళని చూసుకుంటామో ఆ రకమైనటువంటిది రక్షణ కానుంచి మొదలు పెడితే శిక్ష వరకు మనం రక్షించుకుంటాము. కానీ నిందితులు ఎవరైతే ఉంటారో వాళ్లకు శిక్షించే వరకు కూడా ఆ యూనిటీ, ఆ ఫ్యామిలీ లాగా మనం అందరం ఒక టీం వర్క్ చేసి ఒక కుటుంబం లాగా ఇక్కడ ఏ రాష్ట్రంలో ఏ చిన్న పాపకు, ఏ మహిళకు ఎక్కడ అన్యాయం జరిగినా జడ్జెస్ కా నుంచి మొదలు పెడితే, ఎఫ్ఐఆర్ అయినా అక్కడ నుంచి మొదలు పెడితే జడ్జెస్ వరకు ఆ ఒక లక్ష్యంతో పనిచేసి నిందితుడికి కఠినమైనటువంటి శిక్షించాలి, వీళ్లకు మంచి న్యాయం జరగాలి. ఇదే కాన్సెప్ట్ తోటి అందరం పనిచేద్దామని తెలియజేస్తూ నాకు ఈ అవకాశం ఇచ్చిన మీ అందరికీ నమస్కారాలు, ధన్యవాదాలు.
థ్యాంక్ యూ మ్యామ్. మేమందరము కోర్టులలో ఎప్పుడు ఏ అమ్మాయి ఎవిడెన్స్కి వచ్చినా కూడా చాలా జాగ్రత్తగా, శ్రద్ధగా కేర్ తీసుకొని వాళ్ళు ఒక ఫ్రీ అట్మాస్ఫియర్లో సాక్ష్యం చెప్పే విధంగా మా జడ్జెస్ అందరూ కృషి చేస్తూ ఉన్నారు. అందుకే మాకు సపరేట్ విట్నెస్ డిపోజిషన్ సెంటర్స్ అని, చైల్డ్ ఫ్రెండ్లీ ఇన్ కెమెరా ప్రొసీడింగ్స్ అని జడ్జెస్ ఛాంబర్లో ఎవిడెన్స్ రికార్డ్ చేసినటువంటి సందర్భాలు ఉన్నాయి. మేము తప్పకుండా మేము పిల్లల యొక్క హక్కుల్ని రక్షించడంలో మేము కూడా ముందుంటాము. అదేవిధంగా ఇక్కడ ఉన్నటువంటి పార్టిసిపేట్స్ అందరూ కూడా మీరు చెప్పిన విధంగా నడుచుకుంటారని మేము ఆశిస్తూ ఉన్నాము. నౌ ఐ రిక్వెస్ట్ Srimati Anita Ramchandran Madam, Secretary to Government, Women Development and Child Welfare, to present a sapling and felicitate Madam Honorable Srimati D. Anasuya Sitaka.
మా డిపార్ట్మెంట్
sapling. Ma'am, sapling వస్తుంది. మ్యామ్ ఇది థ్యాంక్ యూ మ్యామ్. నౌ ఐ రిక్వెస్ట్ respected Muhammad Abdul Rafi Garu, Principal District and Session Judge, Mahbubabad, to felicitate His Lordship Honorable Justice Sri Justice B.R. Madhusudan Rao Garu with a shawl and memento. Now I request Srimati SVP Surachandra Kala, Principal District Judge, Mulugu, to felicitate his Sir G.V. Subramaniam Garu, former District and Session Judge and Member Secretary, Telangana State Legal Service Authority. Thank you, my lords, and thank you J.V. Subramaniam Garu and Shashidhar Reddy Garu and C.H.K. Bhupati Garu for accepting our invitation and addressing the participants on the various topics. With this session, today's 3 sessions are closed. We will meet tomorrow at 10 a.m. Thank you. The officers who are staying in the MCHRD restrooms, breakfast is provided for them tomorrow morning. Those who are coming from their homes, please understand. Please, all the participants officers are requested to be assembled in the auditorium by 9:30 a.m.